Rules on conflict of laws. Generality of penal laws.
Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law, treaty stipulations, and laws of preferential application. Nationality principle. Laws relating to family rights and duties, or to the status, condition and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy and good customs shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. Lex Recitation.
Real property as well as personal property is subject to the law of the country where it is stipulated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found.
Lex loci celebrationis. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed.
Doctrine of Renvoy. The theory of the doctrine of Renvoy referring back is that the court of the forum, in determining the question before it, must take into account the whole law of the other jurisdiction, and also its rules as to conflict of laws, and then apply the law to the actual question which the rules of the other jurisdiction prescribe. Example: the English law directs its judge to distribute the personal estate of an Englishman who has died domiciled in Belgium in accordance with the law of his domicile. He must first inquire whether the law of Belgium would distribute personal property upon death in accordance with the law of domicile, and if he finds that the Belgian law would make the distribution in accordance with the law of nationality, that is the English law, he must accept this reference back to his own law. Doctrine processual presumption.
Where a foreign law is not pleaded or, even if pleaded, is not proved, the presumption is that foreign law is the same as the domestic law. It is also known as the doctrine of presumed identity approach. Bonus: when does a law take effect? 3 possible scenarios.
1. If the law does not provide for its own effectivity, it shall take effect after 15 days following the completion of its publication either in the official gazette, or in a newspaper of general circulation in the Philippines. 2. If the law provides for its own effectivity, it shall take effect on such date, subject to the requirement of complete publication. 3. If the law provides that it shall become effective immediately upon approval, it shall take effect immediately after its complete publication.
3 rules on human relations. Principle of abuse of rights. Under the abuse of rights principle found in Article 19 of the Civil Code, a person must, in the exercise of legal right or duty, act in good faith. He would be liable if he instead acted in bad faith, with intent to prejudice another. The elements of abuse of rights are as follows: 1. There is a legal right or duty. 2. Which is exercised in bad faith. 3. For the sole intent of prejudicing or injuring another. Damnum absque injuria. Not all damages or injury results to liability for damages. One who makes use of his own legal right does no injury. If damage results from a person's exercising his legal rights, it is damnum absque injuria.
Acts contra bonos mores. Not because a person does not violate a law, she is not liable for damages to the person civilly wronged. Any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs or public policy shall compensate the latter for the damage.
What is acción in rem verso? An acción in rem verso is an action for recovery of what has been paid without just cause. It is enunciated in Article 22 of the Civil Code, which reads: every person who, through an act of performance by another, or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. Acción in rem verso versus solutio in debiti.
An acción in rem verso is considered merely an auxiliary action, available only when there is no other remedy on contract, quasi-contract, crime, and quasi-delict. If there is an obtainable action under any other institution of positive law, that action must be resorted to, and the principle of acción in rem verso will not lie. While in solutio indebiti, mistake is an essential element, while in an acción in rem verso, it is not necessary that there should have been a mistake in the payment. Finally, acción in rem verso derives its basis on law, whereas solutio indebiti is a type of quasi-contract.
Bonus: what is prejudicial question?
Prejudicial question is that which arises in a case, the resolution of which is a logical antecedent of the issue involved therein, and the cognizance of which pertains to another tribunal. It exists when 1. The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and 2. The resolution of such issue determines whether or not the criminal action may proceed.
Hi. I am excited to inform you that our Pinoy Law School stickers are already available in Instagram or Facebook story. Just search msnotabene or law student. You can now use them on your daily stories about how you are studying. You can also tag me if you like.
Intro to persons and family relations. Before a judicial declaration of presumptive death can be obtained, Article 41 of the Family Code requires that 1. The absent spouse has been missing for 4 consecutive years, or 2 consecutive years if the disappearance occurred where there is danger of death under the circumstances laid down in Article 391 of the Civil Code.
2. The present spouse wishes to remarry.
3. The present spouse has a well-founded belief that the absentee is dead, and
4. The present spouse files a summary proceeding for the declaration of presumptive death of the absentee.
A gave birth to a child who died 1 minute immediately after its complete delivery. Did the child acquire civil personality? The child acquired personality, unless it had an intrauterine life of less than 7 months. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. What are the rules on sex determination vis-a-vis? A. Sex reassignment and B. Persons who are biologically intersex. Sex reassignment. Considering that there is no law legally recognizing sex reassignment, the determination of a person's sex made at the time of his or her birth, if not attended by error, is immutable. The sex of a person is determined at birth, visually done by the birth attendant, the physician or midwife by examining the genitals of the infant. Intersex. However, where the person is biologically or naturally intersex, or diagnosed with congenital adrenal hyperplasia, the determining factor in his gender classification would be what the individual, having reached the age of majority, with good reason thinks of his/her sex. Sexual development in cases of intersex persons makes the gender classification at birth inconclusive. It is at maturity that the gender of such persons is fixed.
May the absence of real intention to establish a conjugal and family life nullify a marriage?
No. So long as all the essential and formal requisites prescribed by law are present, and it is not void or voidable under the grounds provided by law, it shall be declared valid. The avowed purpose of marriage under Art. 1 of the Family Code is for the couple to establish a conjugal and family life. The possibility that the parties in a marriage might have no real intention to establish a life together is, however, insufficient to nullify a marriage freely entered into in accordance with law.
There is no law that declares a marriage void if it is entered into for purposes other than what the Constitution or law declares, such as the acquisition of foreign citizenship.
Follow me on my other social media accounts at ms_notabene. Be sure to subscribe and click on the bell icon to be notified whenever I post. Have you more questions regarding my law school experience or have any recommendations for my next videos? Leave a comment below. See you on the next one.